Following the Second World War, the international community had to deal and take stock in itself, the way it conducted the war, what had led to the war, and the tactics and procedures that had been used in the war. This required not just victor's justice, to look at those who had lost the war and to take retribution, but to also come up with a set of minimal constraints that we all agreed is a part of a humane system that we would abide by, the law of war. The law of war is also called the law of armed conflict or international humanitarian law. Regardless, that body of law, built on the pre-World War II treaties, and then broadened to take into account everything from the Universal Declaration of Human Rights to treaty law, the kinds of the CEDAW Convention and the conventions dealing with the rights of children and others. All that goes into this body of law. Now, at its heart, law is also about enforcement. While we hope to set up justice systems around the world that rely on voluntary compliance, we also have to be aware that there are those in society who refuse to abide by any kind of humane law. The best solution, of course, is for countries dealing in a sovereignty situation to have countries deal with their own violence, to deal with their own war crimes. And we hope to foster that where we can. We have also helped to establish regional organizations in Africa, Asia, and elsewhere to deal with law of war violations or law of armed conflict violations. Those are, again, more optimal solutions. But in the final analysis, where national societies cannot deal with their own violence and their own war crimes, where regional organizations have not been able to deal with it, we have been experimenting now over the last 15 or so years with the International Criminal Court. And it's come a long way. From virtually no body of law itself, it has been dealing with building on the lessons learned from the International Criminal Court for the former Yugoslavia, the court for Rwanda, Lebanon. It's been building on that body of law as well as from regional organizations and really becoming more of an effective organ to deal with the most difficult situations around the world. And that's what we're beginning to see. We're also beginning to see in the field that even though violence has continued, even though war crimes continues, that more and more those who are perpetrating that kind of violence are looking over their shoulder to these regional organizations and international organizations and wondering what happens if and when they are brought before the dock. And it is having an impact. We do believe that it's lowering the amount of violence, whether it's in the Horn of Africa, whether it's in Latin America. What we're beginning to see is leaders are taking this body of law more seriously, understanding that the sanctions are available, and recognizing that they have to think about the way they proceed in war. The future for this is unclear. It will require more countries to adopt national laws that work in concert with international criminal law. More countries will have to establish their own courts to deal with these situations, and more regional courts will have to be adopted and strengthened so that crimes can be dealt with in a more localized manner rather than taking somebody to, let's say, The Hague. But the future is also hopeful. The money is there, the expertise is there, the international support is there, and we believe the international climate is right for a broader development of international criminal law, for international war crimes to be more institutionalized. And we think that the future is very bright for the courts.